is over. H.R. 8 will be on the floor of the Senate, and we will see where everybody stands.
Atlanta, Buffalo, Uvalde. And for the shootings that happen every day in the street that are mass shootings we don't even hear about.
And that's why gun owners wanted the Supreme Court to put the statute on hold. They have now said no.
So other families will not have the experience and the pain and trauma that they had to live through.
Ludicrous. That doesn't happen. We are the lawful, legal citizens of the state.
Unanimous decision on ATF national gun control. Breaking news. The 8th Circuit Court of Appeals just ruled on the ATF's new rule on frames and receivers. Supreme Court allows Biden ghost gun regulation. A divided Supreme Court gave the Biden administration permission to execute laws intended to crack down on so-called ghost guns, which are firearms that anyone can make at home using online kits.
Take real cases up to the Supreme Court. We represent the parties involved. We do all the writing.
It was challenged by gun owners. Now the U.S. Supreme Court is allowing New York to enforce this gun control law.
Yesterday, I spoke about the Supreme Court's shocking decision.
That is looking out and reading all the cases decided by the United States Court of Appeals and state Supreme Courts.
Strict limits on guns outside of a home. 2 Supreme Court justices say the New York law presents some serious questions.
Striking down Roe v. Wade. We've had a lot of discussion about that in our whole household.
To try to identify those cases that the Supreme Court might be interested in taking up and reviewing.
Jill and I know how painful and devastating the decision is for so many Americans.
The law in this state bans guns in many public locations and on private property unless there is consent.
Do you think the Supreme Court is broken, in your view?
I think the Supreme Court has made some terrible decisions.
Thinking about voting for a proposal that allows them to get right on this issue. Especially
the trauma experienced by the survivors of this gun violence.
No more hopes and prayers, thoughts and prayers. A vote is what we need.
I work directly with the people who are most likely to commit these crimes or become victims of gun crime.
You can't compare 2013 to 2021. I think there are a lot of Republican senators
who lost their souls to an epidemic of gun violence. They lost their child, their husband, their wife.
In a brief judgment, the court suspended a July 5th decision by a federal judge in Texas that had nationwide restrictions banned. The result was a 5-4 decision, with the 3 liberal judges joining Chief Justice John Roberts and Justice Amy Coney Barrett in the majority. The regulations were released by the Federal Bureau of Alcohol, Tobacco, Firearms, and Explosives, also known as ATF, last year to address what it alleges has been a rapid rise in the availability of ghost firearms. The government describes the weapons as a serious threat to public safety and says they're difficult for law enforcement to locate. The regulation made it clear that ghost weapons fall inside the federal definition of a firearm, making it possible for the government to control them in the same manner as conventionally made and sold firearms. Manufacturers and sellers of the kits are required by the laws to get licenses, serialize their items, run background checks, and keep records. The ruling from a court that often supports gun rights was praised by gun control organizations. According to John Feinblatt, president of the organization Everytown for Gun Safety, Americans across the nation will be safer thanks to the Supreme Court's decision today to maintain ATF's life-saving ghost guns rules in effect while the appeals process plays out. Manufacturers and sellers have sued the government over the laws, but 2 federal judges have ruled in the government's favor.
The ATF is not supposed to make law. That is supposed to be left up to Congress.
Or just take it off and store it far away. You'll be safe.
What changed is that item that was submitted was not produced and was not the item that was marketed.
What about Colombia?
I don't know.
23 per 100,000.
Ludicrous. That doesn't happen. We are the lawful, legal citizens of the state.
Holding it a certain way, it'll continue to bump back and forth against my trigger finger.
Which many have described as the most significant gun safety law in 30 years, and it is.
So you say that the brace changed, and so you had to implement this rule.
Judge Reed O'Connor in Texas, however, reached the opposite result in a lawsuit brought by Jennifer Vanderstock and Michael Andren, who own parts they intend to use to construct firearms. Additionally, plaintiffs include organizations that support gun rights as well as companies who manufacture and market ghost weapons. One of the challengers to solicitors, David Thompson, stated that he's still convinced that we will ultimately prevail on the merits after the legal battle is over. Due to the fact that the decision was not definitive, the Supreme Court could still examine the merits of the case and issue a comprehensive verdict based on its findings. It's possible that the final tally of ballots cast won't match up with how the justices are likely to vote in that case. According to a statement made by an ATF spokesman, the agency wouldn't provide commentary on pending legal battles. Solicitor General Elizabeth Prelonger, who represented the Biden administration in court documents, asserted that O'Connor's ruling put the public at risk by reopening the floodgates to the tide of untraceable ghost guns flowing into our nation's communities. This assertion was made in response to the contention that O'Connor's decision would allow untraceable ghost guns to flow into the communities of the United States. According to counsel for the people challenging the law, the Gun Control Act of 1968 oversees exclusively the commercial market for firearms, leaving the law-abiding citizens of this country free to exercise their right to make firearms for their own use without overbearing federal regulation. The government moved quickly to consult the 5th U.S. Circuit Court of Appeals, which has its headquarters in New Orleans.
Brace that this letter was responsive to. Are you telling me that this brace is exempt from your rule?
We are not finished. We are not finished. We are not finished.
Not one more! Not one more! Not one more!
The most serious readily provable offenses in cases where mandatory minimums are present because it's not warranted.
It could make criminals out of law-abiding citizens, and they've done that in the past.
To make this legal is to remove the 10-inch upper from this Daniel Defense gun.
Or you have to remove it or you become a criminal, and people get worried about that, you know?
It's illegal to own unless you have a permit or a tax stamp.
The ATF decided to change a regulation or an interpretation of the regulation, and so they may just want to SBR right off the bat.
To actually make laws without congressional approval. They're really there to enforce laws.
However, the court rejected to reverse the majority of O'Connor's finding, notwithstanding the government's request. On July 28th, Justice Samuel Alito put a temporary hold on the Texas ruling while the Supreme Court pondered on what course of action it should take next. The conservative majority on the Supreme Court has supported gun rights in a number of significant decisions, including the monumentous judgment in 2022 that acknowledged for the first time that the Second Amendment of the Constitution guarantees a right to bear arms outside the home. This decision was a watershed moment in the history of the court because it was the first time that this provision was ever acknowledged. The upcoming term of the court starts in October, and one of the cases that will be heard during that time will include the question of whether or not individuals who have been accused of domestic violence have a right to carry firearms. The court will consider the implications of that option. On the other hand, the matter of the ghost firearms includes a separate legal question that pertains to the regulatory jurisdiction of the ATF. This decision isn't related to the right to bear arms in any way.
I'm just inspired by the next generation. I think it's a time for a big change.
Since you rewrote the rules of asylum based on the perceived degree of violence in these countries.
Selling more guns in the last 3 weeks than we did in the last 8 months.
But for me, and for most of you, here's what it really is. It's an important first step.
When somebody bump fires, think of this as a bump fire stock and able to move.
To be clear, this wasn't based on violence. This is based on threats specifically to individuals, on gangs.
I don't really see the purpose of letting other people that don't really know what harm they can do.
You specifically said that.
But I said...
What does mandatory mean?
I'm trying to say that...
Does it mean that prosecutors get a choice?
I would expect to see in the coming months and years is a lot of focus on whether or not enough places are deemed sensitive right now.
The Attorney General himself, Ken Paxton, tweeted saying, quote, "What we just witnessed is illegal."
It's not ruled to be attached as a short-barreled rifle. It will not be subject to the rule.
Supreme Court allows ATF to enforce ghost gun rules. A lower court ruled that the efforts made by the Biden administration to prohibit so-called ghost weapons were unsuccessful. However, the Supreme Court put a hold on the finding and enabled execution of the limitations while the issue is being contested. The decision was made by the court with a vote count of 5-4 just hours before Justice Samuel Alito, who handles petitions for emergency relief sought by states, including Texas, placed a temporary pause in proceedings. Justice Clarence Thomas, Samuel Alito, Neil Gorsuch, and Brett Kavanaugh stated that they would reject the request from the Biden administration to resuscitate the restrictions. However, Chief Justice John Roberts and Justice Amy Coney Barrett sided with the 3 liberal judges to put a stay on the lower court's decision. Justices Neil Gorsuch and Brett Kavanaugh stated that they would reject the request from the Biden administration to resuscitate the restrictions. The White House has expressed its satisfaction with the decision made by the Supreme Court to temporarily halt rulings made by lower courts that are impeding the White House's attempts to prevent gun violence. The action of the Supreme Court will keep in place important efforts to combat the surge of unserialized, privately owned ghost guns, which have proliferated in crime scenes across the country while this case is being litigated, according to Olivia Dalton, Principal Deputy Press Secretary for the White House. The legal battle was brought all the way up to the Supreme Court late last month as a result of a request made by the Biden administration to have the regulation targeting ghost guns that is enforced by the Bureau of Alcohol, Tobacco, Firearms, and Explosives, ATF, reinstated, while the matter is still being heard in the lower court. As a direct consequence of the action taken by the ATF in August 2022, the definition of firearm under the Gun Control Act was modified to reflect the new terminology.
Get on the ground now!
I'm a federal agent.
917-110-3.
I'm a federal agent.
Get on the ground!
To run enhanced background checks on young people under 21 trying to buy a firearm.
This government can protect its own people, except for 36 out of every 100,000 for murders.
Types of disputes that would be settled by people yelling at each other, maybe engaging in a fist fight, are being settled with guns.
You're not exempting the same brace that you gave this letter to.
If the brace is submitted, we'll classify it.
Conventional wisdom was we would never get any Republicans to support gun legislation, period.
Are ones where, in fact, it's most likely that they should be bringing the highest and mandatory minimum.
This was done in an effort to combat the rising prevalence of ghost guns, which are untraceable handguns that may be constructed from kits purchased online and assembled in private homes. The rule provided additional clarity regarding the definition of frames or receivers, both of which can be purchased as kits, and broadened the definition of firearm to include ghost gun kits. The legal battle over ghost guns. In order for law enforcement to be able to find the owners of firearms that have been used in crimes, the legislation requires that the people who make and sell particular kits acquire licenses, serialize their products, do background checks, and retain records of their business transactions. The rule doesn't prohibit anyone who's legally allowed to own a firearm from buying, selling, or owning a handgun in any way, shape, or form. Additionally, it doesn't prevent an individual from creating a firearm in their own home. Last year, a coalition of gun owners, advocacy organizations, and firms that create or market products covered by the rule opposed some aspects of the ATF's limits, claiming that those aspects were illegal and stating that they were in violation of the law. A federal district judge originally put a stop to the challenged terms, which prevented the Biden administration from enforcing them.
That requirement for showing a heightened need for self-defense, that was the teeth of these permitting laws.
And within less than 15 minutes, you can walk out the front door here with a rifle or a shotgun.
American citizens in places like New Orleans and Baltimore and St. Louis begin to seek asylum in countries like Honduras and Guatemala.
I don't know if you're referring to any particular incident.
Details of the law, but folks, listen at home. Here's a quick summary of what this law is doing. It's already allowing.
Are demonstrating that blind loyalty to Speaker Dade Phelan is more important than upholding their oath of office.
Might end up being a message amendment because the President of the United States will almost assuredly veto it.
Would you please quit telling this committee that the brace has changed and that's why you did the...
After that, on July 5th, The regulation was declared unconstitutional on a countrywide level by U.S. District Court Judge Rita O'Connor, who sided with the petitioners and decided that ATF had exceeded the scope of its legislative authority. Regarding two of the ATF's limits that were being challenged, the Biden administration submitted a petition to the United States Court of Appeals for the Fifth Circuit requesting that the ruling from the lower court be stayed. The Court of Appeals, on the other hand, decided not to do so. The appeal that was filed by the Biden administration was fast-tracked by the Fifth Circuit, and it's scheduled to be heard in September. The government of President Joe Biden contended that if a stay were granted, the challengers would be free to manufacture, sell, and purchase weapon part kits, and they would only be required to comply with federal restrictions that pertain to the commercial sales of other types of firearms. In addition to this, they petitioned the Supreme Court to halt the order issued by the lower court. The district court's universal vacatur is irreparably harming the public and the government by reopening the floodgates to the tide of untraceable ghost guns flowing into our nation's communities, Solicitor General Elizabeth Prelogar wrote in the emergency application to the court. Prelogar's statement was included in the emergency motion. The damage has already been done once those guns are sold. Some of them will already be in the hands of criminals and other prohibited persons, and when they're inevitably used in crimes, they're impossible to track down. However, the plaintiffs who brought the challenge to the rule contended that the ATF exceeded its power under the Gun Control Act by redefining frame or receiver and firearm in federal law.
She proves you can run for office ending gun violence in the South and you can win.
AK-47 is an automatic Kalashnikov model of 1947.
You can prevent the next tragedy. You can save life. You can save families in the process.
Thought it just like, wow, it doesn't fit the definition, it doesn't fit the rulings, but we better run this up the chain.
Some months later, during an ATF audit, I was told the background check was now a non-approval.
Because they like the outcome of the policy, the banning of a piece of plastic.
ATF agreed to, in 2012, should not be under the jurisdiction of your rule?
Not in the same safe, not in the same car, not in the same bag. Keep them separate.
When it comes to brace technology for pistols, there really wasn't all that much.
They, the ATF, do not want you to put a rifle sight on a pistol.
You know, the braces were a lot different back then. Most of the time you just saw people with like a foam cover over the buffer tube.
They don't want you to shoulder it and have a sight that requires a cheek weld with maybe a 1 or 2 inch eye relief.
This assertion was made by the plaintiffs who launched the lawsuit. According to the testimony of a number of gun owners and dealers who appeared in court, the ATF has been making moves to fundamentally overturn the policy decisions that were taken by Congress in 1968. By aiming to include under its purview goods that aid the manufacturing of weapons by private persons for their own use, ATF has sought to modify the decisions made by Congress in 1968, they stated in their argument. Congress, not the ATF, is responsible for making those kinds of policy decisions. Morehouse versus ATF, legal battles over firearm regulations. The name of the legal dispute that will be covered is Morehouse versus the ATF. It relates to a lawsuit that was filed by gun owners in the United States against the new frame and receiver requirements that were implemented by the ATF.
We can expect in the future that more people will be carrying handguns on the streets in places like Los Angeles, Boston, and New York City.
There's many of you out there, either parents, relatives, and/or victims yourself.
To do anything about what the president is doing to exercise that authority unconstitutionally, as was the case with student loans.
Because people buy hundreds of guns legally and then they sell them illegally.
The decision that the 8th Circuit Court of Appeals reached about this matter was just recently made public, and the urge to be completely honest with you all, it's not favorable. A panel of 3 judges from the 8th Circuit Court of Appeals had listened to oral arguments on this matter. Since then, we've been waiting with bated breath for the decision handed down by the 8th Circuit. The Gun Owners of America, GOA, made an effort to persuade the 8th Circuit that the newly implemented ATF rule violates the Second Amendment and ought to be overturned because of this violation. Their case is supported by the assertion that the Administrative Procedures Act, the Second Amendment, and various other constitutional protections have been violated. Arizona, California, Colorado, Florida, Georgia, Hawaii, Louisiana, Nevada, Oregon, South Dakota, Texas, and Washington were some of the states that joined this case alongside GOA. Also included in this group of 17 states were Alaska, Arkansas, Idaho, Indiana, Kansas, Kentucky, Missouri, Montana, Nebraska, Oklahoma, South Carolina, Wyoming, and Utah. North Carolina was also included in this group of states. The 8th Circuit Court of Appeals, in contrast, came to the conclusion unanimously that a preliminary injunction should not be issued.
In June of 2021, you changed the department's asylum rules so that it could apply to individuals with significant gang violence.
59 times, and then, harmed a bunch of other people, 500 and something.
Most apparent here, a defense of the Second Amendment, which this most certainly is.
Wyme says the Missouri law exposes people to greater harm by interfering with the federal government's ability to enforce firearms regulations.
Well, because he was shooting from an elevated position, he was shooting what is called plunging fire, which is down on an area.
This ruling was made because the plaintiffs were unable to provide evidence that the conduct of the ATF caused damage that couldn't be repaired. In addition, the court decided that the significance of firearms as frames and receivers isn't the same as that of the firearms themselves. Those who aren't familiar with this issue should know that it centers on a lawsuit that's directed against the ATF about the frames and receivers requirement. Because of this new regulation from the ATF, the sale of products that are considered to be weapons is effectively restricted. These 80%ers are now subject to restrictions that are comparable to those that control weapons that have been fully made. An unfavorable judgment has been handed down by the 8th Circuit Court of Appeals in the lawsuit that was brought against the ATF by Morehouse.
It takes extraordinary courage for them to stand up here and retell the story.
Anti-gunners put in there to keep the guns out of the hands of lawful citizens in New York State.
It had no difference to this guy. Straight up, this guy was evil. I mean, he committed murder.
Affect us here, and it was such a breath of fresh air for the Second Amendment people.
This case challenged the ATF's new frame and receiver restrictions. In spite of the restrictions of GOA and a coalition of 17 states, the court decided that preliminary injunctions were not justified. The reasons for this decision were the inability to prove irreparable injury, as well as the fact that frames and receivers are fundamentally different from full guns. This case sheds light on the current discussions in the legal community regarding weapons regulations and how they should correspond with constitutional rights.
Inventing the pistol stabilizing brace to help his friend, a disabled combat veteran, at the shooting range.
You gave testimony that the brave ATF agents are the ones showing up at 2 in the morning after a burglary.
Do any of my colleagues on the other side of the aisle give a whit about separation of powers?
Connecticut delegation, which is incredible. I think on this issue and many others, you're the best delegation in the United States.
No guns were lost. They were stolen by an individual who's now in prison.
And of course, we've gotten a lot of criticism over this. So why is it not a machine gun?
In areas that are poor, mostly minority, there's a mass shooting.
Congress wants to change the law and come up with a new interpretation, then ATF will follow that new interpretation.
The impact of the new ATF rule and legal challenges. Recent advancements in the complex regulatory structure surrounding firearms have created an important legal debate. A specific focus lies on the ATF's amended definition of a firearm, which is a metamorphosis that is weaved through a complicated network of references and which now includes 80%ers under the scope of weapons. Because of this modification, the requirements for serialization and background checks will now apply to certain unfinished firearm components. The conversation was taken to a new level when the ATF published an open letter to the general public. This communication highlighted that even freestanding unfinished polymer frames now fall within the regulation's limits regardless of the absence of supporting equipment such as jigs, drill bits, or instructions. This is because the rule now applies to all unfinished polymer frames regardless of whether or not they are finished. In contrast to the previous declarations issued by the ATF in a variety of legal issues, such as the Vanderstock case, which is currently being considered in a Texas federal district court and will soon be heard in the Fifth Circuit, this new statement will not be made.
And having to tell her that other 9-year-olds were just killed in a shooting is horrific.
And so when you keep going forward like this, it has to go through the 7 cycles of fire.
Get on the ground now!
I'm a federal agent.
917-110-3.
I'm a federal agent.
Get on the ground!
Field background checks could stop a lot of illegal guns going in different places in the country.
Shall not be infringed, and the word infringe means by banning parts on firearms actually is against the Constitution.
This background information is essential for making sense of the ruling handed down by the 8th Circuit in the Morehouse case. The final rule, which spells out the amended definition of a firearm, is the most important aspect of this whole thing. This regulation was challenged in the Morehouse litigation, which was brought before a district court in North Dakota and supported by 17 other states. Their request to the court was to seek preliminary injunction to prevent the ATF from enforcing the new rule for the time being. After conducting an extensive investigation, Judge Peter Wilt came to the conclusion that the injunction was not required given the present state of affairs. As evidence that the ATF's response to issues regarding the Second Amendment during the notice and comment period for the proposed rulemaking was adequate, he referenced it.
Misinterpretations by the ATF in the future. And so that could be one reason why somebody might want to SBR.
And you can apply for that. That's one way to go ahead and make this legal. You can apply for the tax stamp right now. 10-inch AR-15 pistol with pistol brace is now considered an SBR.
They own multiple pistols. I have a 9mm, 10mm, 7.62 x 3.9.
You can apply for the tax stamp and not pay the $200 fee. It's a one-time fee.
We're pro-Second Amendment, but at the same time, we want to take your Second Amendment rights away from you.
The sensitive places doctrine was not at issue in this case and still exists.
He went on to say he looks forward to a quick resolution in the Texas Senate.
So what happens is I pull the gun into my trigger finger.
Who are prepared and carry a gun oftentimes have to make split-second decisions.
That are not Is this brace exempt from your rule?
I can't sit here and classify.
This is the brace you wrote the letter to.
It was determined that the ATF's position that the proposed regulation harmonized with Second Amendment jurisprudence at the time that it was being crafted was correct. The court also mentioned how difficult it is for the ATF to anticipate future developments in the law, specifically referring to the ATF's answer before the Supreme Court handed down its ruling in the Bruin case. The fact that the judge made an effort to lessen the significance of the Bruin judgment is one of the aspects of his ruling that's troubling. It seems that he was limiting Bruin's implications to the proper cost standards that are included in concealed carry legislation. This view hints to an attempt to compartmentalize the landmark decision handed down by the Supreme Court inside a more limited context, dismissing the ruling's possible repercussions on subjects pertaining to the Second Amendment. In conclusion, the legal environment around the new rule issued by the ATF is fraught with difficulties. Despite the fact that GOA and the coalition of states challenged the rule, the court's ruling regarding the issuance of a preliminary injunction was favorable to the ATF. The court took into account a variety of factors, including the responses provided by the ATF during the rulemaking process, the changing nature of the legal landscape, and the significance of the Bruin judgment. The dynamic field of conflict that is the junction of weapons restrictions, constitutional rights, and judicial interpretation continues to be fought over, even as legal battles are still being fought out.
Because he doesn't care about separation of powers either.
The Texas House of Representatives just voted to impeach Texas Attorney General Ken Paxton.
How many guns has the ATF lost? I'm not sure I understand the question.
It will shoot, then it comes back forward. The rifle will then cycle and cock again.
The extent to which this is an unconstitutional violation of our Second Amendment rights. But what is also true is that it is incumbent upon the United States Congress the House of Representatives in particular.
Wyme says the Missouri law exposes people to greater harm by interfering with the federal government's ability to enforce firearms regulations.
Legal challenges persist. 8th Circuit's verdict on ATF's receiver rule. The challenge over carry permits went in a different direction after a preliminary injunction was turned down. The Gun Owners of America, GOA, was the group that ultimately brought the case all the way up to the 8th Circuit Court of Appeals after carrying the mantle of contestation all the way up to the legal ladder. The Judge Stephen Colton presided over the panel that investigated the case, which was given careful consideration. The 3 judges came to the conclusion that the decision made by the lower court to not grant the injunction was reasonable and supported by sufficient evidence. As a direct consequence of this, the ATF's receivers rule will not be put on hold as determined by their decision. The 8th Circuit gave careful consideration to Michael Malloy and Raymond Grunder's oral arguments, which were delivered before the court. The idea that the plaintiffs were unable to provide sufficient evidence to support the possibility of irreparable injury as a result of the ATF's regulation formed the basis for the majority of their conclusion. In order to obtain a preliminary injunction, a party must demonstrate that they're likely to suffer irreparable harm in the absence of injunctive relief, that the balance of equities is tilting in their favor, and that obtaining an injunction is in the best interest of the general public. The position of the court was made clear when it issued the following statement. We find that plaintiffs have failed to demonstrate they will suffer irreparable injury in the absence of a temporary injunction, and thus we need not evaluate the likelihood of success on the merits. The 8th Circuit Court of Appeals came to this conclusion because it was unable to identify irretrievable losses for both the GOA and the coalition of 17 states. This was especially true in a circumstance where the legitimacy of these arguments was being investigated by other parties. The ruling of the 8th Circuit Court of Appeals brought to light an intriguing tactical component.
Pretty clear about the extent to which this is an abuse of the Administrative Procedures Act.
Is it a difficult question to understand?
Well, I'm sure it's enormously high. It's 36 per 100,000 people.
With it off safe, just that little bit of motion, you can hear the click.
I just felt that I needed to be able to protect myself.
In light of the fact that the 5th Circuit was supposed to examine the ATF rule on frames and receivers in the Vanderstock case, the 8th Circuit appeared to carefully dodge considering the likelihood of success on the merits, which is an essential component in the consideration of an injunction. The ruling of the 8th Circuit Court of Appeals didn't address this facet of the issue. Instead, it appeared to delay the matter, which is an action that some people may view it as a tactical maneuver. The decision reached by the 8th Circuit Court of Appeals looks to have been something of a punt on their behalf from a strategic standpoint. This word embodies the idea that the court chose not to fully engage with a critical component of the case, potentially because of the anticipated review of the same ATF rule by the 5th Circuit. This review is expected to take place in the near future. This ongoing legal battle continues to be a topic of conversation that's both intricate and dynamic as a result of the complexities of legal strategy, the ramification of decisions made by appellate courts, and the dynamics of continuous litigation.
To actually make laws without congressional approval. They're really there to enforce laws.
Blatantly denying the power grab being carried out by the executive branch yet again.
The uptick in violence has just been astronomical. The gun violence.
As a kid, I came out of a different movement, the civil rights movement.
Who showed up here said one thing that felt good about doing this kind of event was that they felt empowered.
8th Circuit's emphasis on irreparable harm and strategic deferral. In the complex web of legal proceedings, the 8th Circuit Court of Appeals focused its consideration on the idea of irreparable harm in the Morehouse case. Their decision to postpone the matter to the 5th Circuit, which is a step that suggests a deliberate determination to pass on the responsibility of judging the likelihood of success on the merits, was the central tenet of their reasoning. The court is of the conclusion that the plaintiff's assertion that they may suffer harm to their rights under the Second Amendment in the event that a preliminary injunction isn't granted.
ATF agreed to, in 2012, should not be under the jurisdiction of your rule?
Conventional wisdom was we would never get any Republicans to support gun legislation, period.
The ATF decided to change a regulation or an interpretation of the regulation, and so they may just want to SBR right off the bat.
To do anything about what the president is doing to exercise that authority unconstitutionally, as was the case with student loans.
On the other hand, the court considers this allegation to be nothing more than a risk of irreparable damage. They argue that the plaintiffs didn't provide sufficient evidence to support their claim that an irreparable injury is likely to arise in the absence of an injunction. It's essential to recognize that the result reached by the court at this early stage of the case doesn't in any way prejudge the validity of the claim based on the Second Amendment. The position taken by the 8th Circuit Court of Appeals, which may or may not reflect their current judgment of the absence of immediate constitutional harm, doesn't mean that the plaintiffs, the gun owners of America, and the 17 states will not be successful in their claims based on the Second Amendment. This problem appears to be purposely punted back to the lower court, which may indicate a reluctance on the part of the court to give a decisive judgment on the matter. Given what the court sees as a lack of potential for irreparable injury, it further notes that it will not address the other considerations necessary for a preliminary injunction. The chance of winning on the merits, which is at the very heart of this legal battle, is a consideration that the 8th Circuit Court of Appeals wants to defer until a later date. Their conviction that there wasn't an absence of irreparable injury was the driving force behind their decision to either dismiss or deny the request for an injunction.
Crime for someone who's already been convicted of a felony to possess any firearm.
Implemented by states, my administration is going to focus on how they administer it and whether or not they violate other laws.
Saying you can bring a gun in here, you can't go into with a gun.
Mr. Henderson turned over his firearms to the FBI before he was convicted.
And that's why gun owners wanted the Supreme Court to put the statute on hold. They have now said no.
This morning, though, we're here on a critical issue, gun violence.
Restrictions that New York passed on their statute about where you can have guns, places that don't have a sign.
As a condition of gaining bail before trial, the government has kept possession of the firearms ever since then.
I'm about to sign into law bipartisan gun safety legislation.
Those laws will still be in effect until first the Court of Appeals hears it in New York.
And would like the government to transfer those firearms, which he doesn't possess himself.
The families who, in fact, were victimized by the gun shooting that we've seen.
And then ultimately, if the Supreme Court takes the case, the Supreme Court hears it in Washington.
The recent decision of the Supreme Court to delay proceedings in the Vanderstock case may have some bearing on the outcome of this case. The Vanderstock case was one of those cases that made it all the way up to the highest court and ended with a stay. Because of this new information, the 8th Circuit Court of Appeals might have been compelled to issue an opinion that was a little on the lukewarm side, thinking that they might have an out thanks to the intervention of the Supreme Court. The big picture, on the other hand, paints a complicated image of the landscape. The anticipated decision in the matter of Vanderstock, which will be handed down by the 5th Circuit, is being keenly awaited because it may offer a glimmer of hope to individuals who are contesting ATF regulations.
So the third party can either keep them in trust or sell them and give the money to Mr. Henderson.
And I know how hard it is, and I know what it takes to get it done.
So right now those restrictions are in place. Gun owners are not happy about it.
Many people. There are over 1 million people convicted of felonies in this country.
I was there 30 years ago, the last time this nation passed meaningful gun safety laws.
James commented on the decision, saying she's pleased. Remember, the law as it stands strengthens requirements.
And in many cases, the value of the firearms can be quite high.
Today, for the most significant law to be passed since then, since the last 30 years.
And prohibits guns in sensitive places and requires background checks on all ammunition purchases.
Statute means what it says. It says that a convicted felon cannot possess a firearm.
I'd like to thank the leaders and members of the House and Senate for working together to get this done. I especially want to thank the families.
It doesn't say he can't sell a firearm that the government is possessing on his behalf.
You know who cannot afford to wait? The single mom looking to protect herself and her children from a violent ex who has just been released from jail.
It funds crisis intervention, including red flag laws. It keeps guns out of the hands of people who are a danger to themselves.
About 3% of the sales. But we are talking about the 100% of a life being snuffed out.
Who needs to register as a federally licensed gun dealer and run background checks before selling a single weapon?
No Democrat has ever tried to get anybody's guns. I mean, that's just a lie that they tell, and y'all ought to stop perpetuating the lie.
Time when this seems impossible to get anything done in Washington, we are doing something consequential.
To pass legislation that will do nothing to make Americans safer, but target our Second Amendment and our, sacred God-given liberties.
If we can reach compromise on guns, we ought to be able to reach compromise on other critical issues, from veterans' health care.
At the moment, it would appear that a few of the federal courts are reluctant to engage with these issues, avoiding the complexities of the debates regarding the Second Amendment and ATF overreach. The Fifth Circuit, on the other hand, is one of the few circuits that's willing to investigate and possibly invalidate ATF regulations. Well guys, that about does it for this video, and we'll see you next time.